Hello, my name is Jesse Schley, and I am in my third and final year at the University of Pennsylvania Law School. Today, I am going to be discussing with you the recent case of Chiafalo v. Washington, decided in 2020. You may think that the winner of the United States presidential election is the candidate who receives the most votes. As a practical matter, this is often true. But it is not necessarily true. In fact, since 2000, the United States has had 6 presidential elections, and in 2 of those elections, the winner received fewer votes nationwide than the loser. How does this happen? Article 2 of the United States Constitution says that an institution called the Electoral College decides the winner of the presidential election. The Electoral College is a body of members called electors sent by the 50 states and Washington, D.C., whose only purpose is to decide the next president. Each state and D.C. sends a number of electors to the Electoral College equal to the number of U.S. senators it has, plus the number of members it has in the House of Representatives. After Election Day, the electors meet and cast their votes. In total, there are 538 electors of the Electoral College, and the winner of the presidential election is the candidate who receives a majority of Electoral College votes. Article 2 of the Constitution also states that each state shall appoint in such a manner as the legislature thereof may direct electors to the Electoral College. Keep this language in mind. The 12th Amendment, adopted in response to issues in the presidential elections of 1796 and 1800, provides, "The electors shall meet in their respective states and vote by ballot for president and vice president. They shall name in their ballots the person voted for as president, and in distinct ballots the person voted for as vice president." In the early days of the United States, state legislatures would pick the electors themselves. Now, however, every state for our purpose provides for a popular vote. This means that all the electors from a state will cast their votes in the Electoral College for the presidential candidate who won the most votes in that state. For example, in the 2016 election, more voters in Pennsylvania voted for Donald Trump, the Republican candidate, than Hillary Clinton, the Democratic candidate. So Pennsylvania sent the 20 electors nominated by the Republican Party to the Electoral College, and they cast their 20 votes for Donald Trump. But what if the electors from Pennsylvania in 2016 decided to go rogue and vote instead for Hillary Clinton? Electors who vote against their party's nominee, and therefore against the popular vote in their state, are referred to as faithless electors. Is this necessarily a bad thing? And what, if anything, can we do about faithless electors? Most states have adopted laws that require anyone seeking to become an elector to pledge that they will vote for the candidate nominated by their political party. These laws are called pledge laws. The Supreme Court upheld the constitutionality of pledge laws in Ray v. Blair, rejecting the argument that the Constitution demands absolute freedom for the elector to vote his own choice. However, the court in Ray did not address the question of whether it would be unconstitutional to penalize an elector who voted against their pledge. That brings us to the case before you today. Washington State is one of the many states that has a pledge law, but Washington State's pledge law goes further. Under the law, and if an elector votes for a candidate other than the candidate for whom they are pledged to vote for, they may be fined up to $1,000. In the 2016 election, Hillary Clinton won more votes than Donald Trump in Washington State. Therefore, the Democratic slate of electors was sent by Washington State to the Electoral College. Peter Chiafalo was one of those Democratic electors. Under Washington law, Chiafalo had pledged to cast his vote in the Electoral College for the Democratic candidate. However, Chiafalo and 2 of his fellow electors devised a plan. They decided that they would vote for someone other than Hillary Clinton. They thought if they broke from their party, other electors from other states would do the same. Specifically, they hoped that electors from states won by Donald Trump would also cast their votes for someone else, costing Donald Trump the presidency. Chiafalo's plan did not work, and Washington State fined him $1,000 for voting against his pledge. Chiafalo challenged his fine in Washington State court, arguing that Washington's pledge law was unconstitutional under Article 2. The Washington Supreme Court disagreed with Chiafalo, and then Chiafalo asked the United States Supreme Court to review the decision of the Washington Supreme Court and answer the question left open by Ray. Does the fine imposed by Washington's pledge law violate an elector's ability to vote for the candidate of their own choosing under Article 2 of the Constitution? That is the question you'll be deciding today.